My guest today is Noah Healy. Noah's been on my show before. He's returning now because his case has been accepted by the Supreme Court. Noah has an invention called coordinated discovery market that would establish a better exchange market for commodities. It would result in prices being stabilized and things costing less for consumers, as well as people that make goods and services being able to stay in business. He applied for the patent. It was approved. Basically, he was granted an allowance, is what it's called when you get a patent. Which basically says it made sense. You're allowed to do it. Here you go. Then it was revoked with no explanation of the process of why exactly and who said, you can't do this. We got to take it back. And now he's on the way to the Supreme Court. The problem is two things. One, we can talk about market systems, what's good for everybody besides Wall Street. And number two, the patent system. Why does the patent office even exist? What is it really supposed to do? The purpose? I learned something I didn't know before. And how might that process be improved? I want to start with, in a few sentences, what's happened since you were accepted and docketed by the Supreme Court. We'll break it down later, but give us a short version, and then let's explain what the cost delivery CDM is, and then we'll get back to Supreme Court.
Well, so long-term patent dispute. I've been through the Patent Trial and Appeal Board, the Court of Appeals for the Federal Circuit, and I've now docketed my case with the Supreme Court. There's a couple of weeks, closer to 3 than 2 right now, I think, for the Solicitor General of the United States to make a response, at which point I can rebut that response, and then that goes to various clerks and justices to decide where that's going to wind up on the thing. Either most do actually just get dropped on the floor, but there are a few features in my case where I'm bringing up the kind of thing the court currently likes, and also the Patent Office just released a update to what they consider to be patentable as precedential by the new guy. Trump just appointed a new head of the Patent Office, and there's a case called Desjardins, I believe. I'm not at all certain that I'm pronouncing that even remotely close to it correctly, but it's a pretty big expansion and a very solid grounding for computer-based
innovations, new ideas. To which, for listeners who you were on the show before, and we still have that episode in the archives, for listeners who haven't seen that, tell us about your CDM, what it stands for, your invention, and it's a software. It's really software. It's an algorithm, right?
To some extent, yeah. So I call what I came up with the coordinated discovery market, and the patent is on basically a machine that operates inside. But the big takeaway for sort of the average person is that the markets that we use in New York and Chicago, around the world, Tokyo, London, places like that, use this mechanism of matching up buyers and sellers.
And we're talking about the commodities market.
Commodities markets, yeah. So corn, steel, oil, wheat, rice, the food that you eat, the material that you buy, all that stuff gets negotiated. The prices, the underlying prices are negotiated there.
And it's a big trickle down, because wheat and corn sound kind of like, well, so what? Cereal. I don't eat oranges. But we're talking about raw materials for manufacturing and everything, right? Too.
Rubber, steel, oil, even at this point, shipping gets traded through these things. So,
in traditional economics, what you're taught in school is supply and demand. And for the commodities market, what I never really understood is what you're talking about is how much rubber do we need next year? And you basically are with the commodities market, you're investing in that, making a promise to I'll buy X gazillion pounds rubber next year so they can make it, right?
There's that, and also how much rubber are we going to actually make next year? So if the if there was a big storm and half the rubber trees in the tropics got knocked down, suddenly rubber is going to be a lot less,
Or what's an
in
example of
existence.
something everybody uses, like with AI or their phones? What's something everybody really can't live without? Like I can
Well,
drive my tires on my car another year, but what would really hurt us?
Well, oil is the big one.
Okay.
You don't store gas for particularly long periods of time. The entire system is set up as just-in-time global delivery, and there's a lot of factors that can radically affect oil delivery. And so we see geopolitical events, Iran and America get into a pissing contest. Maybe the straits through which Saudi and Kuwaiti oil and Iraqi oil are being delivered are going to get shut down. Suddenly, oil needs to get more expensive. Or when COVID shut down and everybody in America stopped driving for, a little while, um, they had oil coming out of their ears. The price of oil actually went negative for a little while because the drums were all full. There was more coming on the way, and they just needed to give people money to take oil to stick it somewhere where it wouldn't be an environmental hazard. So
And what core problem does your CDM, your model you're trying to patent, what does it claim to solve?
so the markets that we're talking about solve this supply demand matching and supply demand planning problem. Unfortunately, they also cost trillions of dollars. What my system does is it reduces that cost by essentially however much the people operating that system want to reduce it by. The operating cost of the existing system is sort of directly billions of dollars a year and then indirectly trillions. The direct operational cost of my system is millions of dollars a year. And the indirect costs could be
What costs the billions versus what you're trying to do?
basically information processing. So the existing system is doing things generally on price time windows in the microsecond time range. So there are millions of events per second that occur. And because everybody needs to be watching what everybody else is doing, um, the key players need to be apprised of all of those things in real time constantly throughout the year. And so petabytes of information exist for regulators, are getting processed by people that are involved in doing the trading in order to shave pennies off for
Let me
themselves.
ask it a different way, Noah. Who benefits from the existing system, the volatility in the markets, the imbalances, like you mentioned, it went negative. Who benefits to that? Why are things the way they are? Who benefits from that?
The primary beneficiaries of the current system are the financial elites, the people with access to deep credit that are capable of providing the liquidity that makes the markets function. They basically mortgage the world, and so they're taking a skim off of this arguably useful but also arguably worthless protection. The value to them is the extent to which they can make it useless. The value to us is the extent to which they
Oh,
can make
they're
it.
trying to make money off of it. Literally on the back end as a consumer, I just want tires for my car or gas so I can get to work in my car. I have a real need and a real budget. They're just using it to make money off the top, is what you're saying.
Uh, there's quite a lot of that, yes. So There can be a disconnect. If you go into the grocery store and you pay 10 cents or 15 cents or 25 cents an egg, the farmer's not sitting next to those carts taking, your pennies and dimes. The grocery store and other middlemen organize that between them. For these markets, these exist essentially between those middlemen. So they're not doing transportation, they're not doing production, they're not the actual consumers, they're just negotiating the prices that everybody else sees. And the degree to which the market can separate the producer from the consumer, uh, the the more they can benefit by making those prices further apart. And that's what we've been seeing for the last 5 decades, especially with computerization in the marketplace.
Prices going up.
Prices going up for you, the consumer, prices going down for the producer.
And your system is going to stabilize both the supply to the consumers, reduce the prices, stabilize the
Yeah,
production.
so what my system does is it recognizes the role of the middleman, and instead of allowing the existing sort of free-for-all state to exist, which allows many, many bad actors to insert themselves and sort of make the entire system more expensive for everybody, it directly and solely incentivizes the middlemen that help the producers and consumers negotiate these incidents, which happen all the time, where disasters, whether man-made or natural, actually do disrupt the flow, and we need to plan our way past them in whatever the most economically valuable way
Are you
is.
talking about right now the grocery store itself doesn't participate? A big grocer would actually participate in the system instead of just Wall Street and the farmer.
We could see, yeah, grocery store income input prices coming down, which would then, because of the way their business model works, would cause prices to directly lower uh, in the day to day. We could also see those grocery store chains who have a lot of information potentially being able to utilize that themselves in a much fairer information marketplace. The existing markets are keyed on information, but it's all indirect, and so it requires a large amount of sophistication and, much more importantly, a very large amount of free capital to be able to participate in those things. My system is a direct market in information. It reduces those capital requirements very considerably.
I think I read in your website or paper when you described the CDM system that it stabilizes stuff and reduces the prices because it reduces the corruption because there's transparency. There's more transparency and fairness in the commodity trading.
Well, yeah, that's connected to a bunch of different things. One of the big ones is that petabyte. So the existing system is, if you squint, transparent, but in order to actually understand what's going on, you would have to be able to read effectively at the speed of an internet backbone, and the human brain can't do that. And so it's effectively only transparent to very wealthy actors who have inserted themselves into the center of the system, who can benefit themselves by prying the system apart and making it work worse, so there's sort of more free availability to themselves. So it's only transparent effectively to criminals. My system, by reducing those information loads by factors of billions, actually, becomes something that you could look up on your cell phone and peruse for a day to make a decision, and have a clear idea of where the system actually is and what's going on.
That reminds me of your background. Tell us your background again. You're a game theorist, but you also have nuclear engineering training or something like that, and you worked for some startups, and mathematics is your thing.
Yeah, yeah, math's always been my thing. So I went to UVA back in the 90s and didn't really have a specific direction. Mostly went to college to study higher mathematics. I was in the engineering school, and the classes and professors that attracted me the most were nuclear engineering. So I wound up getting accepted as the final student of their graduate nuclear program, and studied some things like reactor safety and radiation detection laboratories. Nuclear engineering offers a very wide range of mathematical disciplines, because you get involved in some of the civil engineering stuff with sort of statics and dynamics, because you got to build big, heavy structures for shielding and so on. But you also get into the power dynamics, because the entire point of these things is being able to make enough electricity. And then there's the atomic physics of it all.
Yeah, how'd you get from there to where you are now working on? You put a lot of sacrifice and work into this model for the commodity systems. What initiated that?
Well, I decided to sort of build myself a sabbatical after leaving a job that, uh, frankly, I had finished, and they didn't want anybody to have a career at that business. So, that's an interesting decision, but that's what happened. So I parted ways, and I'd been studying mathematics for decades. I started getting very interested in sort of computational math even as a child, and I was interested in whether or not I could, actually come up with anything that was interesting or learn anything that was new. And uh, my background at that point, having worked with computers for roughly a decade-ish, I think, uh, I was very interested in getting deeper into computational mathematics. And so I was working on network communication ideas, and this actually fell out by accident. I wasn't thinking, I had actually studied markets and economics a little bit in college and learned sort of the, 101, 201 type stuff about how markets are perfect. That proof actually relies on an assumption which turns out doesn't have to be true. I accidentally figured out how to violate that assumption.
What assumption is that?
The assumption is that the rate of return for information in a marketplace has to be related to the cost overhead of the marketplace, which for existing market designs is true. And for basically every commission-based business model that has existed in human history is also true. Essentially, uh, there has to be a relationship, because um, in any kind of sort of free entry system, if you had a higher than expected rate of return attached to something, competition would come in and chew that up.
Hmm.
But the thing that nobody realized, um, is that you can act, information is a physical thing that we can actually measure, which isn't me. That's what Claude Shannon figured out, and he's the reason why basically telephones and the internet work, and why we use bits. And
But measuring it doesn't mean it's good information. It's just amount of information.
right, but what we can do with the market structure is we can measure how much information people think that they're bringing to the table, and then aggregate and test it against human behavior and determine what was good and what wasn't. And so we can reward good information under those
Oh,
circumstances.
that's the key I remember on your system is rewarding the good players, not the bad ones.
Exactly, yes.
Um, how does that work again? Reward the good players, not the bad ones?
So effectively, the market operates as an advisor, right? So there's a bunch of people that make oil or rubber or corn. There's a bunch of people that buy it. They all need this advice, this coordination advice about where prices should be, so that the amount of stuff that people are making and the amount of stuff that people are buying is the same amount of stuff. So there aren't shortages or surpluses. So having good advice is valuable to those people. So you set aside a small dedicated commission of the transaction value to that, and then you build this sort of pari-mutuel uh, competition. So, like when you play poker, all the money that goes into the pot then comes back out of the pot to the players, and whoever, sort of wins.
You're rewarding the player that makes the best decisions or gives the best advice.
I'm rewarding the players that contribute towards the good advice. So no one person is making the best advice, but the system can integrate multiple points of view, potentially every single point of view, and work out how much of each of those points of view was ultimately valuable.
And by reward or what's ultimately valuable, we're speaking not of how much Wall Street made on the stock, on the trade, but were prices stable? Were prices to consumers fair? And did the producers of the rubber or the farmer, were they able to stay in business and make a profit on both ends, right?
Yes. So a good price is one that produces a large amount of trade. So the producers need to have a price that keeps them in business and keeps them coming back for more, next week and next year. The consumers also need to stay in business and need to come back for next week or next year.
Because the consumers are the grocery stores too, is what we're
Right,
at.
exactly. Yeah. So the essentially the supply and demand can both be suppressed if you spread price out between them. And what my system does is it pushes those back, and that allows sort of supply and demand to come up and remain balanced.
Everybody is better off. The economy is better off. The prices are better off. The people making stuff, manufacturing, can stay in business and not have to struggle so much. So back to your patents and your resistance with this whole getting your patent so you can proceed with getting it started up. You described, you said it was unrelenting resistance from the patent office. Was it a technical disagreement on the technology in your patent itself or something else?
It very much looks like something else. So the first time I was granted a notice of allowance was actually late 2020. I got the name slightly, the date slightly wrong. I'm terrible with dates, but going through the whole, writing up legalese, I got very specific. They had done a lot of things that were out of band in 2019 coming through 2020, but finally by late 2020 they had agreed that they had absolutely no technical standing to stop anything else. So I was granted a notice of allowance. They then didn't actually honor that notice of allowance.
For those who don't know patents, a notice of allowance, technically that means you have a patent enough so that you can proceed with your business, not have to worry about getting stolen, right?
Not quite. So the patent office kind of works like the DMV. So you go in, you've got some kind of a problem, they assign you to somebody that sort of figures out what your problem is and gives you the correct form to fill out. You fill that form out, and then you take that to the person that processes forms, and then they do whatever you need. The patent office has people called patent examiners, and patent examiners are by law supposed to be technically skilled persons that can analyze things that come across their desk. Functionally, they're bureaucrats who are on very tight time windows, and so they basically are just trying to throw away the chaff as fast as possible. And so you always get a few rounds of these kinds of denials. I wound up having to go back and forth with my patent examiner for around a year, which is not completely unheard of, but is a little on the long side, and essentially had to teach them or make sure that they were engaged enough to pick up a lot of the details. The trick is that that notice of allowance, that's supposed to be clear sailing. You pay the fee, they send it over to the printer office. Like there's not supposed to be stuff that happens at that phase. In my case, somebody who they will not name stepped in and said that this can't happen. Now there are ways to pull things back. They didn't do that, and there's reasons.
Excuse me,
Sure.
because I try to, even though I believe in some conspiracies, I try to question everything. So let me ask you, Noah, what you're saying is once you get a notice of allowance, there is no, it's like you're getting a driver's license. Somebody would have to call you back and say, we're taking your driver's license back. Why? Because you had a DUI or something we found that's legitimate, we missed. Other than that, what you're saying is they won't tell you who, but someone called and said, take his driver's license back
More or less, yeah.
without telling you why.
Well, so it took them a few months to figure out why they were doing it, and the reason they came up with boiled down to 1 equals 2.
I'm sorry.
So they said that it was useless. The claim that it's useless boils down mathematically to the claim that 1 equals 2.
And yet I thought I read someplace that the patent office had acknowledged the superiority of your system over existing markets.
Well, in 2022, the proof that their claim amounted to 1 equals 2 was submitted to them, and they issued me a second notice of allowance.
Oh, somebody else submitted. You're in a battle with
No,
someone
no,
who.
I submitted the proof, and they said yes, that proof is correct. This objection cannot stand. We will we will give you a notice of allowance again.
Okay.
Then 3 weeks later, they withdrew that notice of allowance. This time, so there's a procedure for doing it. This time they followed that procedure, and they said that rather than, they came up with a different excuse. They said essentially that I was patenting fundamental economics.
So I'm back to like, okay, is it conspiracy? Like, is there someone unseen, which there is not letting themselves known? Is there legitimacy behind this or not? And what I'm wondering is, you apply it the second time. I'm imagining I'm the patent office worker, and I go, I'm a smart guy. I stamp it again. Is what is in the background? It seems there's somebody else checking this that's invisible. Is what's happening?
Yeah, so at this point, I still had an attorney. The attorney was in personal communication with the person you're talking about, and that, the examiner and the examiner's supervisor. What my attorney relayed to me is that essentially there were internal bureaucratic pressures from persons that are not accessible outside of the building and who can't be talked about. That they also claimed that they couldn't understand what they were talking about. And so this new objection, which is sort of the opposite of the first objection and also false on its face, was something that they couldn't understand but were told to write down, and it wasn't sort of worth their jobs to go to bat for me. So I could do it, not them.
One thing that came to mind, and taking the deeper conspiracy out of it is, can you, if you want to, can you set it up so you get notified whenever a patent is applied for, and if it's relative to your industry, get notified? Could that be maybe happening in the background, that they have they're listening for patents that are being posted like that, and then they're not telling you who responded, but that's what's happening?
It's certainly possible. So you don't have to note to be applied. The patent office publishes all patents for which a fee is not kept to keep them private as soon as it begins to consider them seriously. So my patent became publicly known in 2016, like December, I think, somewhere around there.
But unlike a open, like if you were going to write a standard for a process, an ANSI standard, a public standard, This is not a public, open dialogue that's happening, or they don't need to tell you who opposed your. Well, it's not even that kind of procedural thing.
Well, yeah, and the procedural thing that it's supposed to be isn't what they're doing either. So at at that second private conference, or actually it was like the fourth or fifth private conference, the examiner and the examiner supervisor told my attorneys that regardless of what argument I would bring back to them, they would not reverse this decision. That they'd been told to do this, they didn't understand why this argument was valid, so they could not understand how it could be invalidated, and so whether or not they agreed with it or not, they would not sign a paper saying that they agreed with it. And so if I was going to proceed, I would need to go to patent court, formerly the Patent Trial and Appeal Board. So that's what I did next.
And now you're at the Supreme Court.
Well, I'm on the steps basically.
Well, getting a case docketed by the Supreme Court is that's a rare feat.
Yes, yes. There are a few thousand of those a year, and there's 300 million of us. So it's not quite a one in a million event to achieve something like this, but we're getting into the zone.
And what does that mean in practical terms?
Well, in practical terms, the the odds still aren't great, and they're it's very arguable whether they're like more like 1 in 10,000 or more like 1 in 10. The variance of the variance is itself totally crazy, um, but the the history of their bad behavior is publicly documented and is a key part of the case. And what we're looking at is a situation where the the United States Patent Office and the United States judiciary has in fact decided to reassert that 1 equals 2 and to bend time and space to say that they're allowed to do that.
They've been hacked by outsiders. They're no longer operating as as a fair government entity.
That's one possibility. They could also be simply operating in their own personal interests because of whatever private, you know, interests they have, or they might actually just be this incompetent.
They're not following the playbook.
That they have radically departed from reason and law at this
Well,
point.
the ironic thing is, if you try to apply for a patent, it's so complicated. You need an attorney because they make it sound like there's all these steps and procedures, and there's a reason for them, and you don't understand. This is here for a reason, and basically they threw all that out under the bus.
Yes, yes, they absolutely did. Um, so there's this thing called the Manual of Patent Execution Procedure. You can read the entire thing online at the U.S. Patent Office. It is thousands of pages long. It's extremely specific, and they're in violation of it. But they, the courts have agreed that using this thing called the blacklight precedent, they're allowed to violate it. And
What's the blacklight precedent?
so blacklight is another crazy story that also highlights flaws at USPTO. So Blacklight is a company. It's now called Brightlight. It's operated by this medical doctor who's a crackpot, who believes that if you don't use quantum physics to model the atom and instead use sort of classical physics to model the atom, that you can make really, really, really tiny hydrogen that he calls hydrinos. And if you could make those things, then you could have a perpetual motion machine. And he's technically right about that. Like if we lived in a physical universe that somehow had these tiny pieces of hydrogen, then the laws of physics that we understand wouldn't be true, and there would be perpetual motion machines. But we don't live in that universe, like at all.
You would know, you're a nuclear engineer.
Well, that and like we teach high school students about this thing called the Rydberg limit. Like atom atom electron orbitals behave in a quantum fashion, and that's just that. Um, so anyhow, this guy applied for a couple of patents. One of them got granted. The second one was on the cusp of being granted. It was even closer than mine was. It was at the print shop. Um,
So what you're saying is they will grant patents that are nonsense, but they won't give you a patent.
that is a thing that happened. Yes. So in this case, what happened is, while the second patent was at the print shop, um, a guy who was writing like an opinion article for Nature magazine, was a physicist and also one of these kind of debunker types of dudes, got wind of the first patent, and he wrote this article basically pointing out that this isn't based on physics at all, that it's an embarrassment that the patent office would allow something that's based on nonsense to be patented. Um, that article, quote unquote, went viral. The Village Voice actually did an article about what doofuses the patent office were. I believe it was a woman running the patent office at that time. Friends of hers who read the Village Voice called her and sent her emails asking her why, she was in such an embarrassing position. And while the second one was at the print office, she, went in, made some calls, told them to stop doing that, and told them to wipe out both patents.
It comes to mind though, there's no harm. It's kind of like a copyright. You can get a copyright even if you didn't write the song. It's just enforcement. It'll never happen. What's the problem with giving patents? I thought they were to protect your intellectual property.
Well, so that's actually not the primary purpose. That's the in legal theory. In practical effect today, the primary purpose is probably to protect intellectual property because business has basically ruined everything. But the actual value of patents and the notion behind them constitutionally is to contribute to what we're known as sort of what's the term, sort of valuable arts or something like that. It's not greater good.
Hmm.
There's a in Article 1, Section 8, there's a specific term that's used for sort of the practical arts, I think is the term that's used. But at any rate, um, the idea is that people should be able to learn from patents things that are valuable. And so while you can't use an idea that is presently patented, you should be able to go and read the patents for the ones that have lapsed and actually do those things for free.
It's to inspire innovation.
That's the entire purpose, yes, legally speaking. And so having false information, known false information in there, is actually counter to the ostensible purpose of the patent
It'd be
office.
like bad AI. AI is giving you the wrong answer. Which brings us back to if the patent office was originally intended to inspire innovation, what does your case to the Supreme Court say about the American principle of open markets and innovation?
Well, at this point, it appears that the government is extraordinarily opposed to innovation or open markets.
Bottom line.
Yes, bottom line. Your personal wealth is directly opposed by the government that we have and has been for about half a decade now.
Then when did the conflict start? Why have a patent office and create the patent office? Or was that 150 years ago or something and things changed? Why the conflict, the change in mindset?
Well, so the patent office is written into the Constitution. Various people credit either Franklin or Jefferson. I'm sure there were, a lot of people that thought it was a pretty good idea. Uh, that that system has had a spotty relationship with innovation, but there are certainly the heroes of that story. Thomas Edison is far and away the hero of the story of the patent office, but it's gone in multiple directions on things like that.
What was Thomas Edison's story?
So Thomas Edison was I'm not sure if he was an orphan or a runaway, but he was a vagabond that was an incredibly fast uh, uh, telegrapher, well, and also learner. And he got involved in trains and telegraphy, and he could always find a job. And he got into electrical innovation. He had invented a number of things which he got patented, and then he created a critical. So ticker tape machines were a thing that existed. They'd been around for a while. He came up with a way to make them more efficient, and he patented it. A financier from the East wanted to buy that patent from him, and he was thinking that he would sell it for like $50 to $70, but he decided that he would, make sure that the guy made the first offer. So the guy's opening offer was um, tens of thousands of dollars. I think it was $40,000 or something like that, maybe 25. Anyway, in sort of modern terms, it was a million plus is what he got. He was expecting, sort of $1,000, and he got $1 million basically. And so he took that money and founded Menlo Park, which eventually Con Edison is one of the companies that sort of came out of that. But at Menlo Park is where Edison put together the research labs that ground out the electric light bulb, washing machines, film, basically modern technology, from sort of phonographs to the wires coming into your house. Edison did a pretty major heavy lift or contribution to 100% of all of these things. Um,
And what does that have to do with the patent office again?
Well, so he patented extensively. He holds the record to this day for the most patents. It's like 2,500 plus. Um, there's definitely things in there that probably shouldn't have been granted, but at that point he was rolling and they were just stamping things left, right, and sideways. But that's sort of the American innovation story. The modern American innovation story is not really quite the same, and one of the big issues is that the skills of the patent office have not kept up with the technology requirements. So up until the like 70s, the patent office had basically decided that the computer industry was just unpatentable. Like chips could be patented, everything after chips was just not intellectual property of any kind. It was all just math. They stayed that way for quite some time. Finally, there were a few key things where they said, oh, actually, they are patentable, and the floodgates opened. People basically said, well, what if I did this thing that everybody's done for centuries, but I, have a computer sitting on my desk while I'm doing it? I'm going to patent that as a patentable process.
Even
And
UIs, like, I mean, people have patented the design principles. Like, there's a button here and a button there on the screen. That one's blue and this red. I'm like, really?
yes, yeah. So literally thousands, hundreds of thousands of patents that definitely should never have been granted were granted. The courts finally started getting embarrassed about this and started sort of pulling back. There's been a long train of pulling back, which
Oh, is that where you're getting? I mean, if it's not a conspiracy, that's your
that
stuck
could have an effect on it. This Desjarnes or however it's pronounced, um, it's an artificial intelligence patent, and essentially, uh, much of AI is being treated the way all computer programming used to be treated. So people that come up with systems that allow you to do something on a desktop instead of a data center are being told, well, that's useless. And they're saying, well, you used to have a data center and now you can use a desktop. That's practically valuable. This is essentially the same argument that I'm making. The existing markets require data centers to operate. I can operate them off of a cell phone. Um,
The
that's
keyword is the comma here is valuable. Does it offer value we didn't have before?
precisely, yeah. And so that new determination. So my decision came down from the Federal Circuit in, I think it was July. I did appeal to them for a rehearing, which they denied. Um, uh, and that would have been in like uh, late October, early November-ish, somewhere around there, I think. Late November, December, the DeJarnay's thing was announced by the current head of the patent office. So the patent office has just changed the rules to make things better for me right after it wasn't relevant. But if the Supreme Court, or this is something that the Solicitor General, when they're looking at it, is going to have to be considering, is that the rules are now shifting sort of in my favor at exactly the time that I'm still in the game. So we'll see.
The Supreme Court, we mentioned the patent office where they're not as sophisticated, they're not keeping up with the technology, the people working in the office. What about the Supreme Court? I picture judges, not technical people.
So the Supreme Court isn't technical, but the Supreme Court is not being asked any technical questions. The Federal Circuit, so the Court of Appeals for the Federal Circuit, is technical, and their behavior I find very disappointing. Um,
You bypassed them already, though. You got past that.
so I'm yes. So they rendered their judgment. They described Alan Turing and Claude Shannon's work as unpersuasive, thereby denying the existence of computers and telephones and the internet.
Oh, I see. You lost that one. That's why you're appealing to
That's
the,
why I'm appealing to the Supreme Court.
but not on the technical nitty gritty.
Not on the technical nitty gritty. I'm asking on the legal nitty gritty. Basically, is it okay for them to ignore facts without any explanation? So if you've engaged with the court, the judge is responsible and has very broad powers within the nature of their court. But their job at the end of the day is to render a judgment. So what they're
And give
supposed to
you an
do,
explanation is the key part.
yeah, what they're supposed to do is describe what the case involves, and then explain how their judgment connects to the case. What the Federal Circuit did in my case is decided that one point that I made was my entire case, created an explanation that, as I say, reverses the times arrow, and affirms that one equals two. Um, but that's not a Supreme Court issue. Like, they don't care about the fact that they're wrong about that. That's not
By the one
something.
equals two, you mean that it has value or not? Yes or no?
Yes. Well, not exactly how it has value. So um, we can analyze systems for their efficiency by describing them with polynomials. Um, and so if you have a system whose polynomial is a square and another system whose polynomial is linear, then as they scale up, the linear system will do much, much better than the polynomial system. So imagine we have this quadratic versus this square versus line competition. So you've got these two kids that are with blocks, and they're trying to make basically the shortest thing possible. But one of them can only build things with blocks, and the other in squares, and the other one can sort of just line them up. So if the kid who's making squares, like the fewest amount of stuff, if the kid who's making things in squares has very, very tiny squares, like he's got like dice that you've got from your Monopoly game, and the other guy's got like big Duplo blocks. In the first few, the Duplo block kid is going to have more material, but eventually, having 100 dice at 10, or you know, 10,000 dice at 100, 10,000 dice is more material than 100 Duplo blocks is. And so the linear kid's got a huge advantage as the numbers get really, really big. And so if you describe a quadratic system, one of these square systems, as being the same as a linear system, one of these one systems, you are claiming that 2 and 1 are the same number. And that's mathematically what's going on.
If the court rules in your favor, what precedent does that set and for whom?
Well, that would be very much up to them. The Court of Appeals for the Federal Circuit actually declared that my case didn't set any precedents because it would be unbelievably dangerous for what they did to me to be precedential.
Hey, and why does that go deeper on that? Break it down.
Well, if they declared as a matter of precedent that the government could violate its own procedures at their whim without a good reason, and that one equals two, then, well, let's say you're paying your taxes later this year, and you decide that instead of owing the government $1,000, you should get $1 million refund. Well, if one equals two, negative 1,000 and positive 1 million are the same number.
I'm not following that, but it sounds like you just make it. It's if the precedent says you don't have to follow the rules.
Well, yeah, but so again, this is kind of like hydrinos. If hydrinos existed, we could violate the laws of physics, but because we'd have to violate the laws of physics to get hydrinos. So if one equals two, then imagine adding one to both of those numbers. So if one equals two, then two equals three. But since one equals two, I can substitute one for the two, and so one equals three. So if one equals two, one also equals three. And if I continue that, I can demonstrate that one equals four and five and six and seven and eight and nine and 10. And eventually I can demonstrate that one equals 1 million and 1,001. And then I can subtract 1,001 from both of those numbers. And suddenly negative 1,000 and 1 million are the same number. It's just algebra.
If a system, an institution, a country of people, a system resists change, the market changing, the people in finance, Wall Street, the farmers, everything. How do you distinguish between legitimate caution? I mean, maybe this isn't for you to answer. You're just trying to get a patent, but you've been through the ringer. Um, but for people who maybe it's a good thing because maybe it's too radical of a change. And what if it breaks? It doesn't work. There's legitimate caution versus we're just protecting the incumbents, the people who just want to do things the same as normal.
Well, so I'm not in a position like to dictate the nature of economic reality to the world. The proposal for CDM isn't I get granted the patent and then I walk into the city of Chicago and just tell the CME group to switch over to a new system and they have to do it or else. The notion of CDM is that it operates at relatively low scales compared to modern markets. And so I would like to give this a try, see how it runs, let it grow on its own. But
Oh, test it in one market, like just
right,
for rubber or just oranges.
sure. Well, and maybe not oranges, but like, oranges in Los Angeles or something. Like you can focus this quite a lot. And that can grow organically, much as the existing markets grew organically to their present state. The difficulty is that it requires a pretty powerful commitment of resources, and I don't really have any resources. And if I were able to get this intellectual property, then that would have its own intrinsic value. And
That's something I learned from the Shark Tank. I read the stories of people who got on the Shark Tank and didn't, and the ones that are accepted, they had a patent because the investors wanted to know that it was safe to immediately start, giving them money to do something with it, and it wasn't safe if you didn't already have a patent. So that's why it's the first step.
yes, yes, exactly. Well, and also with where this is, just getting a patent isn't necessarily that valuable because in our system, things have to be tested judicially before they're really considered to be real. But if I am granted a patent as a result of actions undertaken at the level of the Supreme Court, then that's a very real patent that would have a lot of concomitant value attached to it.
Yeah, yeah. I don't imagine people are going to try to go all the way back to the Supreme Court to challenge your patent.
Right, yeah. You remember when you said that this was right? Well, what if you said you were wrong then? That's not the kind of thing that the court likes to hear about.
What if you're right or
Well, so
wrong?
like, yeah, I'm imagining sort of a hypothetical person talking to Supreme Court justices there. Remember when you said X? Well, what if you were wrong about X? Why, how would you like to say X is wrong and you were wrong and you made a mistake? And the Supreme Court usually responds to that with, what are you doing here? We're not even going to talk to you.
Personally, what's been the hardest part of this? You're pushing against the system at large. Has it been the technical stuff, the math, the money, or just the psychology?
The money is tough. The math and technical is trivial. Unfortunately, I am the most qualified person involved in this, which is terrifying because the Court of Appeals for the Federal Circuit should know these things and should behave really, really differently than they do. And so the psychology is the big lift because, like, if if you suffer an injustice, like, you come home from the grocery store and your home's been broken into, that feels very bad. If you make a police report and the police are incompetent and they don't show up for like a month and a half, and then the person that does show up is slovenly and, clearly disinterested, that's sort of even worse, right? Like it's the system itself isn't capable of functioning, which is why it's breaking. And so I've been trying to have a real conversation about whatever the actual issue truly is, and taking the statements being made at face value and applying the technical knowledge base. I
But the
attached.
people, the people that blocked you in the beginning that are invisible, you'd love to have a conversation with them, is what you're saying, but they won't tell you who they are.
Right, yeah, that'd be fantastic. And and the thing is, like, there are the I actually attached multiple scientific papers to my case to CAFC. Um,
What's CAPC?
Cap, I don't know that that's the correct way to pronounce it, but the Court of Appeals for the Federal Circuit. In my head, I think of that as CAFC, CAFC. The four critical papers that sort of lay out the foundations of what could and could not be patentable and how it's possible to form logical arguments, which sadly has never been introduced to the judicial system before me. But it's the science and math of what computers are and how they work and how information transmission works and how much it costs and so on. Those papers were all written and accepted before the existing law. So the existing U.S. Patent Office was authorized by a law that was passed in 1952. Um, Alan Turing's work is in the 30s. Shannon's work is in the 40s. There was a physics paper from 51. There was another math paper from like the 20s. These things were all known for specialists inside the sort of fraternity with perfect certainty before the existing patent office existed. And here I am in 2025 introducing this information for the first time to people who are constitutionally and legally supposed to be experts in this topic. It'd be like you go to the hospital and you have to explain to your doctor what a thermometer is. Like maybe,
A bone, even name a bone in the body. Yeah.
yeah. I think I broke my arm. Uh, like, is this your arm? Like, is
Can you name the bones? There's
can you?
two of them here.
Right? Yeah, yeah. Let me get your shoe off so I can examine your arm. It's like, wait a minute, doctor.
This is interesting because right now it seems to me on a different topic, artificial intelligence, there's a staggering amount of money and, speculative startups. Everything is AI, 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 and everything on top of that. And all these patents probably go into this same patent office about AI, and that's software and technology too.
Yeah. So the people that are assessing those things have the kinds of technical skills of the kinds of people that I'm talking to, and that is no technical skills at all, as far as I can tell. Um, and and again, the
Speaking of which, is there you probably don't know all the AI patents, but it comes to mind. I wonder if there's an AI patent that's really silly and doesn't fit the valuable criteria, the inspire innovation criteria. It's one of those, this red versus blue dots, like you can patent that. I wonder if how many of those might be getting passed while you're getting denied.
um, there, I would be unsurprised if there's a very strong correlation between economic or political connectedness and patent acceptance. Because if these people are undertrained and don't sort of have relevant technical experience, and I've had experience with several of them, and of course the blacklight, that's high school level chemistry that they did that those guys didn't know. Obviously, there's something going on that's restricting that. Um, I would be very unsurprised if what they largely do is just, run a plausibility check. And they're like, oh, okay, you work for Google. You probably knew what you're talking about. Approved. Oh, you're just some guy who is working out of his basement. You probably don't know what you're talking about. Disapproved. And if the Google paper, has a basic math error in it, and the other thing is fine, they don't care.
It reminds me of a lot of things in society. It's who you know and what initials are behind your name, PhD or whatnot, and that's fine. But at the end of the day, it's subjective. It's not as not as matter of fact as written in the manual.
Well, the it's to some extent it is not fine, because the value of all of those things are proxying to the actual value. Um, you know, Society needs bridges that don't collapse. It needs markets that don't wig out and become incredibly
Oh,
expensive.
here's a solution. I'm being sarcastic. Imagine AI was actually better than it really is. Um, because AI is more just do the math. Is it yes or no? Run the flowchart versus having people in the patent office. What if you had a program replace the patent examiners?
Um, I have strong and not particularly positive opinions about the LLM version of AI. I think the transformer architecture is fantastic. I think that there's some very incredible things that they've done. LLMs, I've actually gotten some use about them, sort of formatting my arguments to make them look like properly formatted legal documentation, for this pursuit here. But content generation and analysis, particularly for novel materials, are something that I am checking and pushing on all of the AIs about, and they're uniformly terrible at it.
They are because they're based on what the statistical norm is. Just because everything's accepted as normal doesn't mean it's true or false.
Yes, they're extremely pro status quo, In my case, I can get them to admit that the patent office is incompetent the and that the Court of Appeals for the Federal Circuit is incompetent. But that's because I can bring sort of more powerful authorities to the yard. I can say, okay, but you know who Alan Turing and Claude Shannon is. Evaluate their ideas in terms of patents. The LLMs can actually generate those arguments very well because, as it turns out, thousands of people who are experts on computational mathematics have been writing about the insufficiencies of the patent office for decades. I think the first articles I read about the sort of interaction of patent law and computational math was back in 2001, 2000, somewhere around there. Um, so
It's
so
embedded deep and long.
so yeah. So the LLMs can basically find these fairly obscure things and put together a cogent argument because the cogent argument already exists. And then when you tell it to sort of continue that cogent argument based on, it's like, here's a federal judgment, here's that cogent argument, continue that cogent argument in light of the federal judgment. It's like, oh yeah, this is wrong, this is wrong, this is wrong, this is wrong. But that's not what the Supreme Court does. It doesn't do me any good. It doesn't do you any good. Uh, and
The Supreme Court of People, and reverting back to what you're speaking of before. Oh, you worked at Google, your patent's accepted.
right, yes, and the LLMs also embody a lot of that as well. They'll constantly try to frame things in ways that make the status quo not so bad. When
It's not intelligent, no, is why.
exactly,
It's just scraping what's already known.
yeah. And so that
Actually, I like the way you keep using LLM for large language model instead of saying AI. You're clear about what it is when you say large language model.
Well, so I think of general artificial intelligence and super artificial intelligence and large language models as fundamentally different things. I don't think that large language models are on the path towards general AI, which is what their their proponents claim that they are. I think that the transformer architecture that enabled large language models has produced functioning superintelligence, and that's not debatable. The game of Go has not been solved, but is currently playable at a level that human beings cannot match. Chess, the premier chess program on Earth is not an AI, but the number two chess program on Earth is a self-trained AI using transformer architecture approaches. Poker, a number of complex strategy games have been dominated by these transformer architectures, and the application of those transformer architectures to those kinds of decision problems have also made strides in mathematics. There's been some interesting micro improvements, which are actually a fairly big deal for things like matrix multiplication and some other sort of niche and some not so niche mathematical
It
topics.
reminds me, Noah, of why I think the word AI intelligence is misleading. It's really a computer. What you just described with the chess games, it's just processing a bunch of what ifs, what ifs, what ifs, what ifs.
Well, the analogy I like to make is, what if when James Watt created the steam engine, we had described that as artificial athletics?
I'm not following that one yet. Athletic.
Well, so human beings have an athletic ability. Some of us can run faster than others and stuff. What if we made a machine that could like lift heavy weights, and we were like, this is artificial athletics. Soon a steam engine will be able to win a gold medal. Well, like that, in one sense, yes.
Well, the intelligence, I don't know how you would define it, but what comes to mind with it's running what ifs, but it had never considered something out of its own domain. Like it'd be like a virus. It keeps going, this is good, this is good, this is good. Yeah, what a and for and doesn't take into account like who's the farmer growing more food. Oh, didn't take that one into account. It's not intelligent.
Right. So computers have a tremendous advantage over sort of humans in reaction time, processing speed, indexing, and a number of other sort of more specific traits that are associated with human intelligence, but are certainly not the full complement of it. And just as strapping steam engines to our joints isn't remotely close to the right way to exploit the Industrial Revolution, uh, I don't think turning our communication over to LLMs is remotely close to the right way to exploit computational technology.
Yeah, and some days I love my chat, and other days I go, you know what? I'm just going to write this myself. Um, Send it off because not even use it to do a pass through. Because is there anything we haven't talked about that you want to add in terms of your CDM and your suit with the Supreme Court and what's going on with everything with that?
No, no, we've definitely hit the highlights, and this was cathartic. So thanks for that.
Thank you. Wishing you the best. Real excited to. I'm rooting for you. And they'll have to have you back again after when you win your case.
That I would be very happy to come back after that happens.
Do step three. What happens now?
Right.
Thanks so much, Noah.
Bye bye.